Oh
Just
man.
left the prisons, man. So I'm blessed.
Yeah, it's a blessing to be here, man. We gonna dip right into it and shit like that. Well, you know what I'm saying? I appreciate you for being on the show early the week. You know what I mean? Dropping off the free knowledge. I said, yo, I gotta get this dude back going. And you know, it was long overdue. I said, it makes sense. This season two, let's start off
Hmm.
right, man. Well,
Definitely.
Hassan Bennett with your story, man. What's going on? All right, let's all right, because I got like a little 2 hour, it's my birthday week. Wifey taking me out night and all that. So we gonna get right into it. I ain't gonna even
Yeah,
hold you up.
enjoy
We gonna get
life.
right into it. Yeah, man. So you did 13 years, like be on the serious note, 13 years,
Uh-huh.
4,600 days in the prison.
Hmm.
You you know what I mean? Shit, you represented yourself. You know what I mean? You didn't have an attorney. You know, at the third trial, we gonna get into it. But take me back to 2006. We want to go all the way back when you first got locked up for this crime. What was
Uh-huh.
going through your head? Like, take us from the beginning.
I was like, man, they can't find me guilty for this shit. I thought I was gonna go home the next court hearing.
Mm,
When you get booked, most people are optimistic. You don't want to
right.
believe that the city gonna do you dirty. You don't want to believe the state gonna do you dirty. So when you hear things and you see, from my experience, which came from movies and shit like that, it was like, all right, they ain't gonna find me guilty.
Right.
They need, and listening to rap music, I'd be like, all right, they need evidence. They need
Right.
evidence to find somebody guilty. They ain't got no evidence. So I'm
Yeah.
like, all right, I just gotta wait till the next court hearing, and I'm gonna be out. Next
Wow.
court hearing, postpone. Next one, postpone. Then I go to my prelim,
And that was in
and
November, right?
no, my first preliminary hearing was on Valentine's Day,
Oh wow. Take.
2007. It was on Valentine's Day, and they put a kid on the stand against me. The homeboy had to only be like 17, 16, 17 years old. So they put him on the stand, and he was like, no, he ain't do it. He ain't had
Mm,
nothing. He wasn't there. And then they introduced this statement. So when they introduced the statement, they going over the statement with him. Then they called Detective Pitts,
mm.
well-known detective, infamous detective in the city, corrupt bull. So they called him on the stand, and he like, yeah, well, Corey was down there, X, Y, and Z, Mont was down there, and they told me he did it. So I'm like, all right, but the witness just said I didn't do it, but they held me over. It was like, all right, hold him over for trial. And I didn't understand it at the time.
Right.
Like, why the fuck you hold me over? And dude just said I ain't do it. Why you gonna hold me over now? But the
Right.
judge held me over, and this is the thing with preliminary hearing. A lot of people think preliminary hearing is like trial, and it's not. Is up to the DA. Everything is on the DA at preliminary hearing. So it's not about credibility. It's not about whether we believe what the witnesses are saying. It's not about if the evidence is reliable. It's, does the evidence presented, Bruno, does the evidence that was presented fit the elements of the crime? So
Right.
each crime has elements, proofs, burdens of proof you got to prove. Does it have a prima facie case?
Mm,
Did this DA present a prima facie case? And what that means is, without the credibility, can X mark the Z? Can one match the other? Can one match the other? And with the witness, not even with the witness testimony, with his statements,
mm.
with the statements that was presented, that satisfied the elements of the crime without credibility determination. So they hold it over for trial and all right, we're gonna let the jury decide if they're gonna believe you.
Wow. So that's your first shot right there. So you go back. So after all that going on, all that happened, you go back to the jail. So what's going through your mind and shit? Like, was you nervous? Like, was you like, damn, I'm about to
I was
really
like,
get
all
banged?
right, that was some nut shit. I'm like, that's
Yeah.
some nut shit. But once I got back, see, I didn't go to the jail. I'm in jail today. Jail
Okay.
today is different from jail back then. I was in Pitt.
Okay.
So once I go back to the jail, it's guerrilla mode. I'm back on
Mm.
survival mode. All right, where's that? Where's that? All right, what they doing? What they doing? What everybody doing? Because I'm back surviving now.
Right.
Once we lock in the cell, I tell my cellie about it. Yo, they did X, Y, and Z. They held me over. I didn't even know what the next thing was to come. The next thing that came was discovery.
Yeah.
And at the same time discovery came, I found out, yo, the prosecutor gonna go for the death penalty against you. But even then, it didn't hit me. It didn't
Wow.
hit me like, all right, they really going at me. I'm like, all right, I ain't got nothing to worry about.
Wow.
This just a waiting period. I'm just waiting. I'm in the jail mix. I just got to survive through the jail and I'll be right out. I ain't know shit.
Yeah,
Like most of us to go in, we don't know shit.
for sure, for sure. You definitely weren't hitting the books up yet or nothing. You just,
No, I want to hit no books up yet.
oh man. All right, well take it to the first trial. Take it to the first trial and shit like that. I know it, you was found guilty, whatever the
So,
case may be.
no, the first trial, a week before the first trial, they had went and so it's a homicide and it's a aggravated assault, or what people know as an attempted homicide.
Okay,
So
that's the charges. Okay.
they go get the surviving victim. Like, okay, you saw him in the visitor room. He's like, all right, yeah, I saw him, but he ain't the one that did it. Like, y'all tripping saying he did it. So they
Mm,
go scoop him. Then when trial come, the prosecution put the surviving victim on the stand. The surviving victim is telling them, I ain't say that shit.
mm,
He wasn't there. I know he wasn't there. It was a tall guy that shot me. It wasn't him. So the DA is like, yeah, okay. Well, boom. Once again, they introduce the statement. They go through line for line with the witness, with what was written in the statement. The witness is denying some things, saying, okay, yeah, I said I know him, but I ain't never say he did it. Y'all was saying he did it. Y'all was telling me he did it.
mm.
So they go all the way through it with the witness. They let it go. All right, we don't got no more questions, Your Honor. So now my lawyer comes up and he's going at it with the witness. And the witness like, no, he ain't do it, but he dropped fast. Like
Mm,
he ain't diving in. So a lot of times when witnesses recant, that's what it's called. When a witness says something, denies a statement that points to the guilt of the defendant or the guilt of the accused, they call that going south, or they call that recanting. South
right.
is like the slang word for it. Recanting is the professional word for it. So they call that recanting. So a lot of lawyers go at the tactic wrong in one, wrong in all. But
Mm,
then the law says, the jury instruction and the law says that the jury is allowed to believe some, none, or all.
okay.
So what the prosecutor does is the prosecutor matches the statement to the scene evidence, right? So
Okay.
they call the crime scene expert, let him testify how the scene was, show all the pictures. Then they call then they call the detective that
Mm,
allegedly took the statement. The detective would get on stand and say, yes, he told me this, he willingly told me this, X, Y, and Z. So they had intercepted a letter from the surviving victim. He had wrote me
okay.
a letter like, yo, I know you didn't do it.
Mm,
If they saying statements, that ain't even there. That I ain't make no statements. That's fake. The statements is fake. And you know us, we in the streets like, man, all right, whatever, man.
right,
Whatever.
right.
And niggas in one ear telling me, yo, he made them statements. He trying to get you away. And then there's niggas in the other ear like, yo, you never had no problem with him. You wasn't there. It was no way for him to say you did it. And then in the statement, he's saying, listen, I'm trying to go at the guy that shot me.
Mm,
I know it wasn't you. Me and the guy that shot me, we got our beef going on out here. You just trapped up in there. So,
right.
all right. So they introduced that, but he said, even if you did it, I wouldn't rap. So the prosecution used that little word in
Mm,
that joint and said, look, he's only switching his statement because he doesn't want to look like a rat. I had a jailhouse witness
okay.
that came forth, right? And he was saying that I told him I did it. Now, this is why you can't trust dudes in the law library. This goes on to one of the reasons why I went and studied it my own, because this dude was acting like he knew the law.
Wow.
He was giving me advice, and I'm telling him I didn't do it. And he act like, all right, what do you have on your favor? When I tell him what I have in my favor, he bounces it to the DA, right?
Mm,
The
right.
motherfucker tell the DA, listen, well, he tell the detective, listen, Haas did, he told me he did it. He told me he was gonna get X, Y, and Z to come here and say he didn't do it.
Wow. Wow.
Everything I told him, he flipped around and said, boom. But then nowhere in the statement did it said I did it.
Wow.
Right? But then he flip around at trial and say, no, he told me he killed his friend. Mind you, the deceased was my friend, and the surviving victim, they was all homies. So the DA using this like, no, they're homies again. That's why That's why the victim is lying. That's why the victim is coming up here denying it now, because he has to go back to the hood. He don't want to look like he telling on his friend. So then the jury deliberating for like 5 days. Somebody knew one of the jurors. A kid knew one of the jurors. He went back to the jury and said, listen, I don't know what you're doing back there, but I'm here to tell you from what I see, from what I'm hearing on the streets, he innocent. Now, here we go again, the hood being ignorant to the law. So the jury reports it to the judge. She this the guy, she showed a text message. That's exactly what it read. Look, I don't know what y'all doing back there, but from what I hear, Hassan is innocent. They lock homie up. They give me a mistrial.
Damn. Wow.
Right?
Wow.
For just saying that. You can't mess with the jury when they in deliberation. Just be him, but in looking at it, common sense looking at it, you like, all right, he just trying to do the right thing. But in trying to do the right thing, he got himself caught up.
Oh
right?
shit. Okay. Okay.
So I get a mistrial. I go back to the prison. They raid my cell. And raiding my cell, they take my phone records and a whole bunch of other shit. Right?
Wow.
Let me get a water real quick.
Go ahead. Go ahead. Take your time. Take your time.
So now, but at the same time, I'm like, all right, they took that shit, whatever. I know now we ain't playing that some none of all shit, and we ain't playing with this trial. This shit not no game. It's not Matlock. It's not what's that movie called? Miracle on 35th Street. It's not none of that shit. This shit serious. This shit look dark. She was too confident in saying what she was gonna do. This lawyer wasn't convincing to me, so I damn sure know he wasn't convincing to the jury. Let me see what goes about. Let me see the angles. So I began to read the law, and I'm like, listen, they talking. They said my name. They said my PP number on the stand. I typing them. You're not allowed to say a PP number because it shows a criminal past. You understand? All right, so I get that down. Okay, we're going. How do I do this? So it's called a motion in limine, where you eliminate stuff. It's a motion in limine. It's an evidence motion where you can take away evidence from the trial. No, they can't hear about that because it's not relevant to the trial. They may find me guilty just because of that, and we don't want that. Also, he said that he found shells in my crib. So I'm like, show me the shells. Y'all talking about y'all found bullets in my house. Show me the bullets. Well, we don't know where the bullets are. They also said they found my phone records. Give me my phone records. Show me my bullets. Show me the bullets. Give me the phone records.
For sure. Right.
We lost them. Well, don't mention it then. If you don't have it, don't mention it. If don't try to paint the jury with some nonsense unless you proving it. Because if you did find bullets, it could have been for the case, or it could have not. Now I know I ain't had nothing to do with it, so I know it wasn't. Even if you did find something, I know this shit ain't got nothing to do with it. Produce that shit. And they couldn't produce it, so don't say nothing about it. That was the first motion I presented. Now, in finding out the motions, I'm like, hold on. Oh, you mean to tell me all I got to do is send a motion, 2 copies or something to the clerk of courts, and they going to send it back? They going to send that, they going to stamp it, or we received it and send it back? So then I looked at it, I realized, okay, and the attorney has an obligation to keep up with my docket and what's being filed in the clerk of courts, even though they're not going to entertain it. So if you have an attorney, right? If you have an attorney and you file something, the courts cannot entertain it. That's called hybrid representation, right?
Okay.
The attorney has to file it.
Okay.
Right? And your attorney cannot go directly to the judge and have a discussion without the DA being there because it's hybrid representation. All that falls under hybrid representation. But what the clerk of courts would do is stamp it, mark it on the docket so your lawyer can go look at it and decide if he wants it. So once I figured out that, I said, oh, this sucker don't want to answer my letters and shit. I'm sending all my letters to the clerk of courts now, and I'm going to get it stamped. So I listed all these witnesses I wanted him to present. I told him I wanted him to go secure my phone records, present it. Boom. Second trial come up. My co-defendant
That's how I was
now
about to ask you.
becomes,
You had a cool D, right? That's
yeah.
how I was going. That's how I was going to ask you. All right.
So
Go ahead.
first of all, let me rewind before my first trial. When I
Mm-hmm.
first got locked up, it was just me.
Okay.
Ballistics came back and said the gun that they were saying I allegedly held was not the gun that killed the guy. So then they went back and interviewed all these witnesses and ended up, they got statements from 2 more witnesses.
Wow.
And then ended up locking up my co-defendant. Like, you killed the guy. And in his statement, it said, no, Bahas was with me. So now the fishy stuff starting to surface, but can't nobody capitalize it because of the substantial evidence rule. The substantial evidence means if a witness goes south, then the prosecutor could present, or whoever witness that is that put him on the stand could present the prior statement if the witness is there, if the statement was adopted, meaning he said, that's my statement, or it got a signature on the bottom of it, and the statement was written verbatim. Verbatim is, as you say it, I'll write it down.
Right.
You understand what I'm saying?
Right.
So if they could prove that, then the statement can be used as more reliable than a trial testimony. So it's like, oh, no matter what you say at trial, we gonna find him guilty. The jury can find him guilty off the statement if that witness appears at trial, because he gotta deny it. So once he swore in, if he denies it or goes south, they present that statement, boom, call the detective after he get off the stand, go through the statement, let the detective tell you what happened. Now the jury can believe the trial testimony or the statement. So now it puts the witness against the cops. And you know, 9 times out of 10, the cops win. So my second trial come along, my rappies now cooperate. Now, when you cooperate, this is the part I don't like about cooperating. When you cooperate, they don't just put him on the stand and say, go. They prep him, right? Once they prep him, right, then they let him plead guilty. In his guilty hearing, in his sentencing, not sentencing hearing, in his plea agreement, he gets on the stand and he admits to the crime he did. So anything that goes outside of the DA's, it's like a practice run. And that's what I don't like about it. After you prep him, you get a practice run, because now you get to go through it, like, and the DA may say, well, what about this? And yeah. So it's a practice run. So by the time he got to my actual trial, he was ready. He was ready to say everything they needed him to say.
Wow.
To corroborate anything they want, any mishaps in the statement. He changed it from, I got the gun from so-and-so, to no, now I got the gun from Haas, but I knew it was so-and-so gun.
Wow.
So he get on the stand and he testified for me. We attack him with what we could. Okay, you got a deal, right? All right, man. So then the jailhouse witness come on, but then the victim come on and say, no, Haas ain't do it. I'm telling y'all, Haas ain't do it. X, Y, Z. 4 people that the victim told I didn't do it came and was like, listen, all right. They presented the statement. Then I presented 4 people that, listen, he ain't do it.
Right.
He told us he ain't do it.
Damn.
And the letter was presented. Boom. After the letter was presented, my aunt come testify like, no, he was in the house. He was in the house with me during the time that they saying he was out there. They saying I was smoking weed. They paint me like the average nigga. Out on the block, smoking weed, gambling, robbed the nigga over $20. That was the whole theory. Okay. I come like, no, he was in the house, but you know, that's family. When you family or friends, that's a known bias.
Okay.
Right? When you get contact with a witness, that's a known bias. So these are all things that discredit the witnesses I present. Well, what did you do after the victim told you that he ain't do it? I end up telling him. How'd you tell? Oh, you wrote him? So that's a known bias. Oh, y'all cool then? Enough to write him in jail? Yeah, that's a known bias.
Wow.
I testify in my own favor, but you know, I got something to lose at the end of the trial. So that's a known bias. I lose.
Wow. And it was 11-1, right?
No. I get found guilty. 12-0 in favor of guilty. Same day, judge sentenced me to life in prison. Now, this is the thing. When I get life, I'm soldiering up. The worst part about getting life, when it hit me, is when I turned around and saw dudes that stood up all their life. They rumbled. They they done went through everything. When I saw tears coming out their eyes, I was like, oh,
Damn.
it's real. This ugly. Cause the tears to me, when I saw the tears coming out their eyes, it was tears of sorrow, but also it was like, damn, they giving up already.
Wow. Wow.
It's like, damn, what y'all crying for? It ain't over. Let's keep fighting. Y'all crying. Look like, what's up? We still swinging.
Let's go.
Let's keep
Right.
going. It ain't over. We still got appeals. Cause mind you, I learned the lesson as a kid. You plan for the worst and hope for the best. So I had already been planning, all right, if I get guilty, I'm going to be able to use this to get back and this to get back and this to get back in.
Right.
So
Right.
I go
Right.
upstate.
Okay.
When I go upstate, a week
What
later,
prison?
my
What
rap
prison
be
is that?
coming in.
What prison exactly? You
Greatest.
was.
I go
Oh, you was at
straight to
Greatest.
greatest.
Okay. All
You
right.
know, the rest stop. I
Right.
go upstate a day before Christmas.
Okay. Dang.
Right? My rap be
Mhm.
coming a week later. He go right to the guard and say, I can't be around him. They lock him upstairs. In
Mm.
a cell upstairs. So his man had already came to me, and somebody he messed with already came to me like, yo, I heard my man did X, Y, and Z. I'm like, all right. So I'm like, yo, your man on the block. Holla at
Mm.
him. So he like, yo, what happened? He holla up at him like, yo, Mont, what happened? He's like, oh man, I got a little time.
Mm.
I got 15 to 30. He didn't get 15 to 30. He ended up getting 25 to 50. But
Wow.
the thing is, as they talk, and he be like, yo, you testified on Bull? He's like, yeah. He like, and then he starts saying, Bull wasn't even there and I testified on him. Fuck that nigga. He ain't our squad. So what I
Wow.
did is I went around and I got people to write what they saw, what they heard him say.
Smart.
And I was asking my lawyer to put it in, but he wouldn't put it in. So I put it in my damn self. Other
Mm.
people was like, yo, fuck him up. And I'm like, no, like, I ain't touching that, man. Because if it's records that I touch that, man, they damn sure ain't gonna believe him. They gonna have evidence that, look, he beat him up. That's why he changing his story. They was
Right.
fighting. That's why he changing the story. So I ain't touching that, man. I'm in it for the freedom.
Mm.
That's short. Remember we was talking the other day about playing for the long end, playing for the back end. I'm not
Right.
doing that shit. I'm not staying here all day.
So you was playing chess from the rip. You like,
Man,
all
fuck that.
right.
I'm not going. I ain't touching. I'm not touching nobody involved with my case because I know that they're gonna use that, and I'll be stuck here forever.
For
And
sure.
ain't no punch gonna do the damage of being in prison for life, yo. Ain't no punch worth it.
Mm. So at that point that you got right into the library, you got into the book.
I was
You got
already in the library from the
okay.
county, so I just
Okay.
continued.
Okay.
Right,
Okay.
so I wrote that down, filed a motion myself for newly discovered evidence.
Mm.
When I got an evidentiary here 5 months after my case, 5 months
Mm.
after being found guilty. Boom. All four of them guys came and said what he said. The prosecution called himself being smart. They already discredited my witnesses by saying we were all there together. They wrote it for me, X, Y, and Z.
Mm.
And then they asked him, well, what you think about rats? You know, we don't like rats in our hood. So they already had discredited him. They called themselves being smart and calling they co-defendant. Like, we got him. We signed a deal. He admitted to it.
Wow.
But when admitting to doing it, it's okay. You did it. All right, he ain't do it. Well, who did it? He said, I did it. They be like, well,
Wow.
who you do it with? He's like, I don't know all that. Well, where you get the gun from? It just appeared. It wasn't believable as his trial testimony. I told you about some, none of all. So the judge was like, man, you just not trying to be a rat in prison. I'm
Wow.
denying this. You lying now. So now I go back up to Greene County. I'm not in Greatest no more. I'm at Greene County.
Wow.
So I go back up to Greene County. I'm in the hole. I done got into some shit with a guard now. Camp Hill. I'm in the hole. I gotta wait to get out the hole. I'm
Damn.
still going to the law library, but every time I go to the law library in the hole, I'm looking up recantations and I'm reading the same shit. Like, you can believe son under all. Recantation is the most unreliable source of after discovered evidence
Wow.
because it deals with a witness admitting that he lied. Now, if you look at if it's the most unreliable source of after discovered evidence, well, let's look at trial. How they look at it in trial. just because it ain't after discovered, it's still unreliable, and you got to view it. So now I'm putting the pieces together, but all the pieces together I'm putting together ain't like what Styles say. Come down on the pill, and it ain't as easy as these motherfucking rappers be talking about.
Talk
This
about
shit
it.
looking like I'm cooked.
Damn.
So what I do is I say, you know what? I'll read this case called Commonwealth versus Johnson. And it says investigation is the most important part. It's the most pivotal part of a criminal defense. So I read this case over and over and over, and I'm looking at it like, oh, shit. Investigation is the most pivotal part of a criminal defense, because once you get locked up, the prosecutor has all the evidence from the cops, the detectives. They have all the evidence. So they lock you up because they say, okay, this evidence is strong enough to get a conviction. This evidence is strong enough to meet my burden of proof. So though the prosecution has the burden of proof of proving you guilty, from the date of arrest, they believe, okay, this is what we have to find you guilty. And once we present this evidence, now it's on you. So I didn't understand that. So now I'm looking at myself like, all right, once you get convicted, the burden of proof is no longer on the prosecution. The burden of proof is on you. So now I'm looking at it like, okay, I got to play like a prosecutor. If the prosecutors depend on the cops to get the evidence, then I need somebody to depend on with that same oath to get the evidence. So what I did is they took some bread off me when I got booked.
Okay.
Right? I got booked with some paper, but when I went into jail, I still had to call people for other paper because they took bread off me. They decided to put what they wanted on a property receipt. So I said, okay, I could fight a forfeiture here and get this bread back. So I went and filed a motion to return the property and show where I got the money back. And they sent me a deal. Okay, we'll give you every dollar back.
Damn, dope.
So I don't want to go further. I just want to get enough to hire a private investigator. Because if the burden of proof on me, then I'm playing prosecutor now. So I need my private investigator. That's the defense police officer. That's the one that's going to give me all the evidence to fight back. So all right, so when you win, the city doesn't send the money to the jail.
Talk about.
You got to send somebody down there to get the money. So I'm like, who I'm going to send down there? If I send my folks down there, they're going to pinch off the top. I can't send my folks down there. My man fuck around and get booked. Driving down there, coming back. He probably go down there dirty or some dumbass shit.
Or trying to flip
don't got a license. How am I going to secure every drop of this money and put it to where I needed to go? So what I did was I hired a private attorney, and I gave him, listen, bro, I got $3,912 down there, right? What I'll do for you is I'll let you get 75 to go security, and then just keep the rest for the case. Wrote him a power of attorney so he can go get it. So when he did it, now he's working on the case. All right, this is the person I want you to go interview. I was on the phone during the time of the crime. Get my phone records. I was on the phone with this female. Go interview her about the phone records. Boom. So he tells me, oh, yeah, somebody called me after you got found guilty and was telling me that he saw it. But I was like, I never thought nothing. All right, go interview him too. Go interview him too, and I want you to interview a witness that was in the discovery. Deshaun Sims. Go interview him. Go interview Marcia. Go interview all these people that I feel could show like, bro, I ain't do this shit.
Right.
So he interviewed the chick I was on the phone with, and he found a new witness. Mind you, because I already know the law now, I know that my direct appeal, I don't got no hope. So once my direct appeal was denied on Superior Court in October, I needed more time to secure this other interview to get ready for PCRA.
Right.
So I sent him out again. I begged the lawyer. I said, listen, could you please just file a allowance of appeal to the Supreme Court? She was like, well, what do you mean? It's going to get denied. I said, I don't care. I just need the time. to be ready for PCRA. She said, what? But it's going to be denied. I say, listen, when it comes to ineffective counsel, that means to decide if you got a lawyer that's bad, I got to meet 3 prongs. I got to show that what I want to do has merit, meaning it cooperates with the law. I got to show that the reasonable basis. There's no reasonable basis not to do it. And then it got to change the outcome of the proceedings, the outcome of the trial. Man, I'm holding myself to these standards. I'm asking you to do this because it's going to benefit me and later. It's a good decision. I got to go interview this witness. By the time that's done, the private investigator had to work. We be ready for PCRA. So Barbara A. McDermott, she said, okay, I'm going to file it. I like how you put that. You holding yourself to a lawyer standard. I'm going to file it. So she filed it. By the time the Supreme Court denied it, I already had the witness interviewed. I had both witnesses interviewed in hand. I had my PCRA written out. Supreme Court denied my petition September 29, 2011. By October 6, 2011, my petition was inside the clerk of courts and stamped.
Oh, man.
That's like 7 to 8 days later. So now I'm ready. I'm going.
Oh, man.
I already know investigation is the most important part of a defense. So now I'm not even worried about a lawyer. I'm like, if I load the lawyer up with everything you need, I'm cool with that. I don't want no lawyer. Go ahead. I'll take a court appointed lawyer. Give me a court appointed. I'm still focused on the evidence. So I asked the Barbara A. McDermott, she was becoming a judge. So I said, can I get my file? She said, send somebody down there and I give him your file. My pop went down there. She gave him a big box, large box. He sent it to me. It was a disc in there. They sent it back. He sent it to me again. When I opened up the box, I found my phone records. I got another piece of evidence. Mind you, I told you they've been firing at me this whole time. I got a couple clips to fire back now.
Right.
A couple clips in the stash.
Now we on your third trial. We on trial 3 right now, right?
I'm guilty.
Okay.
I'm guilty right now.
Okay.
So I tell my friends, listen, it's a website called UJ Sportal. Look up each witness and send me their criminal history. And send me their history. So they send it to me. So I find out every time the jailhouse witness spoke to the prosecutor or the detectives, he had an open case. Whether it was denied, whether it was dropped by trial or anything, it shows bias at that single time. So if you can believe some, none, or all, and you can take the statements as more reliable than the trial testimony, I'm attacking every time he said something. Every time he said something. Oh, when he first got locked up, he was on probation violation. He got locked up for burglary, and he had another probation for drugs. Boom. That's why he lied this time. All right, trial what happened? He was locked up that day for robbery. He was on probation for 2 drug cases. All right, the burglary was already dismissed, but that's the reason to lie at that. The last time he stole somebody's gun, he was on a probation for the robbery. He was on a probation for the drug case. If they ran that wild, that boy would be facing 12 to 24. Man, so I calculate that. All right, that's another good one for a pill. Right, so I got that. I got the phone records. I got my drug test. It showed that I ain't even get high. So all that, he was out there smoking weed, taking Xannies. Your boy don't even get high. Your boy told the first time the man called me and said, yeah, I'm gonna be your supervisor. He wrote down there. I said, man, get the fuck out of my face. I come to see you when I want to see you, and I will come to see him whenever I wanted to see him. But one thing that happened, I never gave a dirty urine. I did what I wanted to do, but I never gave a dirty urine. I was going to school. I was going to school.
Yeah.
I had a lot of good things going for me, but I didn't give no dirty urine, and I just was arrogant. I was an asshole.
Yeah.
You know what I'm saying?
Yeah.
So that discredited that. So now I'm like, he just sitting on my case. The court appointed they gave me just sitting on my case, not doing nothing. 2013 came around December. I filed to get rid of him. He finally filed an amended petition January 2014. We have our hearing March 2014. He talked me into keeping. Cool. He said he's gonna file another petition. I put it on record. Listen, he said he's gonna correct all his mistakes and file another petition, and that's why I'm keeping him. Anything else? I can do it myself, but I'm keeping him because that's what he said he's going to do. The second petition was horrible. I wrote the judge. The clerk wrote me back and said, listen, you already said you're going to keep this lawyer. But mind you, when I filed to get rid of the lawyer, I filed my amended brief as well and attached all the evidence to it. Right?
Right.
So then, at the same time in 2013, mind you, I'm in a hole. I get the paper, and it says Detective Pitts is shady. It said he got 3 cases. He's shady. So now when I go out to get out the hole, fuck playing basketball. Fuck. I'm still going to the library, but I'm not going as much. I got to go to the yard now because now I want to know how many people got Detective Pitts.
Right.
And I'm talking to people. How many people meet me at the law library if you got Detective Pitts? Yo, anybody on your block, meet me at the law library on this day if you got Detective Pitts. So we all get around. I'm like, yo, what your witness say Detective Pitts did to you? He said, man, he beat him up. I said, my witness said the same shit. I said, what did he say about the signature? He said, he ain't signed that shit. He signed the release form, or he signed a property form, or he signed this. And I'm like, my witness said the fucking same thing, man. All of our witnesses ain't lying, bro. All of them, they don't even know each other, and they saying the same shit about this man. So I'm looking at it, but then the case come out that says newspaper articles is unreliable. So I'm like, how the fuck am I gonna get these other witnesses from? So I write the paper, try and get in contact with them. No avail happened. The prosecution filed a motion to dismiss. Dismiss this shit is bullshit. Fuck this petition. That's basically what it's saying. He ain't attached the evidence to it. That was their excuse. That was the Samuel Ritterman said, I didn't attach the evidence to my petition. Now, mind you, I attached the evidence to my petition, but when the lawyer filed his petition, he didn't. But he didn't say the lawyer didn't file the evidence. He said defendant, which is me.
Wow.
The judge said, okay, I'm going to deny this shit. I write a letter every day. Dang, shoot a letter at him. Keep shooting
them up.
Keep shooting a letter at him. So they like, okay, we're going to give you a graze your hair and we're going to see what's up. I go into graze your hair and I say, Your Honor, it ain't my fault. The DA said he ain't attaching the evidence to it. I attached the evidence to mine. So they're like, well, I said, my original PCRA. As a matter of fact, you got it. She's like, you sent it to me? Yeah, I sent it to you. So she looked in the file and all the evidence is in her file. So you ready to deny me when you got all the evidence.
Wow.
And if you got all the evidence, that means your clerk sent all the evidence to the lawyer, which means he got all the evidence. She kicked him out the courtroom. She tried to get me to get another lawyer to represent me, but I had a problem with that because now that lawyer got to get familiar with the case. And while that lawyer getting familiar with the case, I'm still sitting in jail.
Wow.
So I said, no, I don't want another lawyer. I got this case. Ain't nobody better than me on this case. I said, matter of fact, you can give me a private investigator. Mind you, I've been kicking all this money out the PRs. I still want